Look, thank you everyone for joining. We've just waited to open up the session because we had a number of attendees, and I'm just watching the numbers. So we'll just get started now. It is 5 past 10. Good morning. My name is Thelma Schwartz. I'm the Principal Legal Officer of the Queensland Indigenous Family Violence Legal Service, QIFVLS. Today we are presenting our second ever webinar, which is a bit of a historic moment for us here at QIFVLS, in relation to the Family Court of Australia and the Federal Circuit Court of Australia and the impact of coronavirus on family law matters and what you need to know. The presenter of this session today is Solicitor Team Leader Simone Chee. Simone is based in my Townsville office and services in and around the Townsville catchment area. Before we actually get into the presentation, I'd actually like to start with an acknowledgement. As this presentation is occurring electronically from different sites in Queensland, I'm here in our Cairns head office and Simone is in Townsville, and we've got people from all over Queensland and Australia. I wish to show my respect and to acknowledge the traditional custodians of the various lands upon which we all work today. I would like to pay my respect to elders of those various lands, past, present and emerging, and to celebrate the diversity of Aboriginal and Torres Strait Islander peoples and their ongoing cultures and connections to the lands and waters of Queensland and Australia. I would also like to acknowledge and pay my respect to all Aboriginal Torres Strait Islander people who are joining us today, and I'd like to extend that welcome to everyone. Thank you for being with us today. I am now going to hand over to Simone. I'd also like you all to be aware that we are recording this session. It is our intention to actually share this session on our YouTube video, our YouTube channel. So it's another innovation that we have come up with in the times of COVID-19. I will now mute myself and stop my video and hand over to Simone.
Thank you, Thelma, for the introduction. I thought I'd just start off with a quick introduction about who we are. We are a not-for-profit Aboriginal and Torres Strait Islander community-controlled organisation, and we deliver culturally appropriate free legal service, non-legal support, advocacy, and community legal and community education services. So we have been in operation since 2010, and we are governed by an Indigenous controlled board of directors. QIFVLS provides legal and non-legal support to Aboriginal and Torres Strait Islander people who are victims or survivors of domestic and family violence, or sexual assault. Our services are delivered in a culturally appropriate and trauma-informed manner, and it's complemented and enhanced by integrated case management practice. So as you can see from the map up on the screen, we service areas. We have offices in Brisbane, Rockhampton, Townsville, Mount Isa, and Cairns. Our head office is in Cairns, and we service up to over 50 plus at-sea communities as demonstrated on this map right here. And that includes attending and appearing in circuit magistrate courts. Very briefly, our practice areas includes the provision of legal advice and full legal court representation casework. And that's subject to our clients meeting our eligibility criteria and obviously subject to conflict checking. So we are practicing in the areas of domestic and family violence, child protection, family law, victims assist applications, sexual assault matters, and minor civil matters. And as I mentioned earlier, we also deliver community legal education sessions and community education. The Court and the Federal Circuit Court's response to the coronavirus, aka COVID-19. We know that the government on a federal scale and on the state level have introduced measures to stop the community transmission of COVID-19, and that's really just for a health perspective. How are we going to reduce the risk of transmission to the community? What we're going to do is we're going to practice social distancing. We're going to make sure that we're going to risk manage this. And along that road, there have been measures that have impacted the traditional way that courts usually operate. So where in the past you would have had to go in person to the court to run your matters, whether it was a mention, whether it was an interim hearing, we've now moved away from that because of the risk of transmission with COVID-19. So what the courts have done is they've looked into the situation. They say, okay, we're not going to have to adapt because we still need to provide this essential service to the community. What do we need to do in terms of adapt to make sure that we're still providing this service, which is consistent with government-issued health advice? So the courts really play an essential role across many jurisdictions, but especially so in hearing and determining matters relating to the breakdown of marriages and family relationships. And that can include the division of marital property and determining parenting orders. So for example, where will the child of a relationship live, and who will they spend, and how will they spend time? The courts, like many other businesses across Australia, have had to rapidly introduce measures to ensure that the essential services that they provide continue even during the time of COVID-19. Just like I referred back to, majorities of matters are being conducted by telephone. So that's for matters that don't actually require cross-examination. So you've got your mentions, you've got your duty days, where the matters that require cross-examinations, those are going to be run by way of video link facilities such as Microsoft Teams or other similar platforms. And what's great about this is, this is, I know we hear this a lot being bandied around in the news, in the media, by politicians. They say, well, these are unprecedented times. And the courts have adapted to that. They've said, look, what we're going to do is we're going to give priority to urgent matters. We're going to issue new practice directions to make sure that we are adapting to the situation as it's evolving. As more government measures get introduced, we're going to make sure that we're not compromising on the quality of service that we're providing to the community. Like I said, majority of matters are being conducted by telephone or by video link. Physical appearances in the courts are only required in exceptional cases. Now, I know, for example, in the Townsville Registry, I don't know of any physical appearances that have occurred to date since the measures have been introduced. I think the literature coming out of it has been the courts may consider your request to appear in person, but they've got to be very exceptional circumstances, and they are going to be implementing face-to-face safety measures. What else has happened? Mediations are still occurring, but they are going to be done by telephone or electronically. The courts have substantially adjusted, including engaging in long-term digital transformation. This has involved the rollout of Microsoft Teams to each judge, each registrar and family consultant. It should be noted that this technology was rolled out to 101 judges, 35 registrars, and servicing up to 40 different locations. This digital transformation has allowed each judge and registrar the ability to conduct hearings electronically from each registry, including defendant applications, trials, and appeals. So during this time, the courts are prioritizing urgent matters and those concerning the safety of children. The newly developed practice directions implemented in response to COVID-19 relate to the electronic filing of material, the viewing of subpoenas, signatures on documents, and affidavits, and annexures to affidavits. For example, if we look at the Joint Practice Direction, or JPD2 of 2020, special measures in response to COVID-19 relating to electronic filing, viewing of subpoenas, annexures to affidavits, signatures on documents, and affidavits and fees. The Joint Practice Direction applies to all family matters and contains the following key features. 1, requires documents in a matter to be e-filed or emailed to the relevant court registry for filing. do not post your hard copies or deliver them. The courts have directed for those who are self-represented or those who do not have access to the necessary technology to contact the registry for assistance. So this policy really is just to minimize any unnecessary handling, because we've obviously read how we want to reduce the risk of transmission. So the court has said, we're going to adapt to this situation. We're going to really embrace technology and run with this, because we don't want there to be a delay or a backlog in terms of community members being able to have their matters heard in a timely and efficient manner. We've also got subpoena viewings at registries by appointment only. You would know that if you wanted to make an appointment, you would have to email your relevant court registry. And appointments to view subpoena material should only be made if the matter is critically urgent. So there is, I guess, a discouragement of people attending court unnecessarily to minimize that movement, and to say, okay, if warranted, if necessary, if critically urgent, then email us and we'll adapt to the situation. We'll make sure there's appropriate safety measures in place. Documents such as affidavits, financial statements, and consent orders can be signed electronically by the deponent of the material and or the lawyer on the record. And again, that's just moving away from our usual practice and bearing in mind the government measures in regards to risk management for COVID-19. And in a further departure from normal procedure, the courts have acknowledged that COVID-19 poses significant challenges to having affidavits and financial statements sworn. What the court now is permitting is for filing of materials such as affidavits and financial statements to be signed without a qualified person witnessing those documents. There is, of course, a proviso on that to say that the judicial officer may require the person who has signed the documents to be available by telephone or video link or in person at a subsequent court event to swear or affirm that the contents of the document are true and correct. So it's really quite momentous, because, you know, practicing in a relatively regional office, we service clients who are as far north as Tully, a 4-hour drive, and it may not be so convenient for the clients to come in, have the documents signed by someone who's qualified. Even if they're not going to come in, being able to access someone who does have those qualifications in that local region, given the COVID-19 restrictions, it really is a momentous decision by the court. And it really is in recognition of, you know, we can't keep stalling things. We have to administer the course of justice in a timely and efficient manner. So what other practices have been, the practice direction has allowed for the deferral of fee payments in circumstances where registry staff are working from home and unable to access an FPOS terminal. Where this situation arises, registry staff may defer a fee payment. Where registry staff are able to physically come into the court registry, they'll continue to process payments as per normal. The process for online payments remain unchanged. Now, in relation to physical appearances, we've had practice directions issued to say you need to be appearing by telephone or video link unless there are exceptional circumstances where face-to-face in-court hearings will need to take place at the request of the parties involved. This is determined by the courts on a case-by-case basis, and for all of the safety of parties involved, the application is only granted by the courts where absolutely necessary. I can't say personally from my workload that I've had to make that request, but by all accounts, it seems that from the literature that's coming out has been, you need to give as much information to talk about why you're requesting for that face-to-face hearing. The more information you give to the court, the more they're able to make that decision to say, okay, I understand why we can't have this run by way of a video link or by way of a telephone link. And I'm going to consider this and give it thought. In addition to the practice directions that we have discussed, the court has issued or rather has implemented the COVID-19 list, and it's fantastic. You know, it came in operation on the 29th of April, 2020, and was introduced in response to an increase in the number of urgent applications filed in the courts over a 4-week period from March to April, which represents a 39% increase in the Family Court of Australia and a 23% increase in the Federal Circuit Court. So the court has said, all right, we see this surge in numbers. We need to actually be proactive in terms of how can we make sure that we're able to deal with applications that are coming through with recognition that these are very exceptional circumstances. So what they've done is they've introduced the COVID-19 list, and in the words of Chief Justice of the Family Court and Federal Circuit Court of Australia, the Honourable Will Esther, probably mispronouncing this, and I do apologize, the Honourable Will Elstergreen, the COVID-19 list is designed to quickly identify and to deal with cases that need urgent attention in the COVID-19 crisis. So what we have here is examples of matters where it's suitable to the COVID-19 list. Family violence, where there's an acknowledged increased risk due to family violence resulting from the COVID-19 restrictions imposed on families during COVID-19. Other examples include supervised contact, where current parenting arrangements involving supervised contact and the contact center is closed, or the supervisor of the contact is unable to perform this function and parties cannot agree to an alternative arrangement. And I think we've all seen this. I understand that Relationship Australia Townsville has closed for the moment pending the development of COVID-19. And what's happened is parents don't go to court because they want to. You know, they arise out of situations where they're not able to come to an agreement, and they do need that active interference. So the court has said, okay, in these exceptional circumstances, we're going to place that as a consideration to putting you on the COVID-19 list. Other examples include border restrictions. I think we're all very familiar with the political stoush that's happening between state premiers. And it is a live topic at present, and it's an issue where parents live in different states or territories, and a child or children can't travel between parents' residence due to border restrictions. You know, you might have a parent in Queensland and you might have another parent in Victoria or New South Wales where they don't have those border restrictions, but they're not able to comply with court orders because of those border restrictions. So the court has said, we're going to take that, we're going to take this issue, and we're going to put this as a consideration under the COVID-19 list. Other factors, other issues include medical treatment, such as if there's a party or a child that tests positive to COVID-19 and they're not able to fulfill their parenting obligation. There is still an expectation that when you're making an application to be on the COVID-19 list or to be considered for the COVID-19 list, that you would have complied with requirements of alternative dispute resolution prior to filing that application, or when it's safe and appropriate to do so. When considering the application to be put on the COVID-19 list, there has been direction from the courts to say the National COVID-19 Registrar may also still make orders for the parties to attend electronic mediation if appropriate to do so. So if you have a look at the joint practice direction for the COVID-19 list, it does set out the criteria for the list, its operations, and instructions on filing an application in the COVID-19 list. I don't actually have it in here, but if you do check the practice directions, it's great because it does actually set out an example of, you know, the cover letters that the courts are expecting for you to provide for them to consider, okay, if we want, why should we put this in the COVID-19 list? Are you actually meeting our criteria? And it's a great way for you to look at, to say, I need to really be framing my mind in this and thinking about this, you know, can we actually have this hurt urgently to be put on the COVID-19 list because we do meet these criteria as set out? Why is this relevant? I mean, it really highlights family violence. So we've heard the federal government say, we recognize that in these times, because of restrictions, because people are required to self-isolate for the safety of community, that there is, we expect there to be a trend in domestic violence, you know, where a victim would be isolated and unable, or would be harder for them to reach out. And we see statistics time and time again that shows, you know, that family violence is a very serious concern. It doesn't just impact on the victim himself or herself, but children, but parties around. So we've got on the window here saying that when most women leave a violent relationship, they do end up having to move out of their home. And if you think about it, you know, if you're having to leave a violent relationship, you're having to move out of the safety, the security of your home, you're in an especially vulnerable position. We've got statistics to show that Indigenous women are 32 times more likely to be hospitalized due to family violence than non-Indigenous women. Intimate partner violence is a leading contributor to illness, to disability, and premature death for women aged 18 to 44. So I guess tying back to what we've talked about earlier, the restrictions that have been brought about by COVID-19, by federal government, by state government, they've all been designed to stop the community spread of the virus. Initial responses by employees have included ceasing face-to-face contact, to stop travel to outreach communities, and to allowing employees to work from home. And these health measures have included social distancing, which further compounds social isolation. And for a victim and for the children wanting to leave that relationship of domestic violence, they're quite literally being trapped with their perpetrator. So I think these statistics, it's really an important reminder about the number of key findings in the area of family violence, as demonstrated on this slide. It's also important that we remember in Australia that 1 woman is killed each week from an act of domestic violence, and that women is statistically more likely to be killed in her home. There's going to be very few of us who's going to argue against the literature that's come out saying that there's impacts of family violence on children are long lasting, and it results in higher rates of social and emotional problems than in other children who would not have experienced family violence. And then we've got here to say children of mothers experiencing domestic violence have higher rates of social and emotional problems than other children not experiencing domestic violence. Domestic and family violence is the leading cause of homelessness for women and their children. And that just ties back to the earlier statistic that said that, you know, victims of domestic violence and family violence are more likely to leave their homes in search of leaving that, in search of escaping that family violence. So what have the courts done in addition to those practice directions? Well, there is the Lighthouse Project, and what that is it's a name given to a risk screening and triage pilot The name and symbol of the lighthouse was chosen for the project to, quote, eliminate risk and to provide guidance and support to families experiencing or at risk of family violence and other risk behaviors such as alcohol or drug abuse or mental health problems. The pilot will be conducted in the Parramatta Registry, the Brisbane Registry, and the Adelaide Registry, and will be running for 2 years. So this pilot is expected to start in mid to late 2020, and there are interconnected process parts to the pilot. So firstly, screening parenting matters for family safety risk at the point of filing. Secondly, to triage matters to an appropriate pathway based on the identified level of risk. 3, maintaining a specialist list to hear matters assessed as involving a high risk of family violence in the Federal Circuit Court. This special list, excuse me, the specialist list which will be called the AVID list, will be operating alongside the Magellan list. We've also got the harmonization of the courts, and it's really vital because we've got here both courts, the Federal Circuit Court and the Family Court of Australia, saying we need to approach identifying risk in a consistent way. And so what that's resulted in is both courts have decided to implement a harmonized, if you will, harmonized notice of risk, a notice of child abuse, family violence, or risk. It's acknowledged that this project will take some time, but the courts are committed to its implementation. One of the key changes under a harmonized notice of risk is that the notice must be filed in both the Federal Circuit Court and the Family Court of Australia. It is important for the courts to align its processes and practices, especially where it relates to information relating to children and risk. Judges need to be armed with holistic information about multiple risk types like mental health, substance abuse, so that judges, while assessing risk on the other hand, can also make orders that are in the best interest of the child. And that really just ties us back to, the basic principle, where we're going to make decisions, the child's best interest is the paramount consideration. Okay. So you've got a court date, you've been told you've got to go in person. Is it actually safe to do so? Yes, it is safe to do so. Hearings of your matter will be conducted in accordance with face-to-face in-court protocol. So similarly, while they've had those 2 practice directions we discussed earlier, the courts have also said, look, we realize that electronic hearings, telephone hearings are not always going to be sufficient. There are exceptions to the case. There's going to be, so face-to-face in-court protocol allows for physical appearance and determination of the matters while ensuring that the risk of infection for judges, court staff, and court users are low. So what are the key features of face-to-face in-court protocol? Again, priority given to urgent matters. We've got staggered listings, and short matters are listed at 30-minute intervals. So in Townsville Registry, if you have a look at the court list, you'll see that matters pre-COVID-19, we would have had up to 20 or 30 matters on a duty day. Those matters are now being staggered, to say, look, we're going to put several matters on at a time. We're not going to have them all running at this in the one slot at time. We're going to assign a 9 o'clock slot. We're going to assign you a 9:30 slot. Short matters, again, listed at 30-minute intervals. Longer matters are not to take more than 1.5 hours. And based on the literature that I've read, I haven't actually experienced this myself, is where the matters are going to take more than 1.5 hours, that's it. You're going to have to come back again. Might have to check on that to see that that's right. But there is definitely an encouragement from the courts to say, where that there's going to be longer matters, you should be making those written submissions. I know in the Townsville Registry, the courts are very appreciative of any written submissions that you can submit ahead of your court date. I know that in Townsville, it's drummed into us, you know, if you file something, the material will be read. In addition to everything that we've discussed in relation to face-to-face in-court protocol, there are restrictions on numbers of people in courtrooms, and that's been 8 persons to the courtroom, excluding the judge and his associate. I've read about how your clients are discouraged from attending where they've got legal representation. So we keep hearing this in the news, but it needs to be said again. You need to be social distancing, practice social distancing. So you need to be clear 1.5 meters of the persons around you. When your matter is finalized, however tempting it is, you need to leave and you do not linger. There is additional cleaning implemented to wipe down the counters. And that's really just about reducing risk to subsequent users who do end up coming in, reducing risk to the court and the court staff. There is also discussion about a use of contactless thermometers. So the courts are currently investigating the availability of contactless thermometers to allow for non-invasive temperature measurements before a party physically enters the court registry buildings. If you're unwell, you need to immediately notify the court. I think we've all read in the news, it just takes that one super spreader before chaos erupts. So be smart, you know, just if you think you're coming down with something, make your excuse, tell your solicitor, tell the courts, and seek another adjournment date. I know we've had guidelines from the courts to say in Townsville, if you're not feeling well, you need to ask for another date to adjourn the matter. If however, you know, you don't actually start feeling those symptoms until you're in court, immediately notify the court, leave the building, go get tested. Your matter will be adjourned to another date, and you will be notified of those dates. The courts will then ensure that there's deep cleaning measures applied to reduce the risk of transmission. Okay, you've got clients. They're asking you, I've got parenting orders in place and they're not being followed because mom says it's not safe for them to travel and bring the child over to change over. What can I do? We've had from the Chief Justice of the Family Court of Australia and Chief Judge of the Federal Circuit Court of Australia, the Honourable William Elstergren, releasing a statement in relation to parenting orders during these times of COVID-19, with a key theme of act in the best interest of the child. At the end of the day, you need to try and make sure that you're following orders as much as possible, that you are aware of the COVID-19 list, as we discussed earlier, where you're meeting those criteria of, you know, we've got issues to domestic violence, we've got issues to making those medical decisions, or issues in relation to border restrictions. What can we do? And really actively encourage seeking legal advice. Well, just back to what I said earlier on the 26th of March, 2020, the Honourable William Elstergren released a statement saying, whatever happens, you really do need to act in the best interest of the child. And that's really tying back to the core principle. Whatever decisions you make has to be in that child's best interest. It's really a good reminder to parents where they're facing a lot of anxiety about what's going to happen. And I think because of what's happened, what we've seen with the numbers, with economic forecasts, with concerns about health, it is a very high tense situation. Just actively reminding parents to keep the interest of their child at the forefront of their mind is so vital to ensuring that continuity in regards to care of the children. Are we still having interviews with family consultants? Yes, there's been joint practice directions issued to say that interviews will still be occurring, but they will be done by way of telephone or video link. Similarly, you know, we know that the courts say, we know that there are going to be exceptions to the rule where physical appearances are required, but that's going to be under limited circumstances. If you have a matter in the court, is mediation still available? Yes, again, mediation is still available, but it's to be conducted by way of electronic mediation over video conferencing facilities such as Microsoft Teams. I know from the Townsville registry that there has been a bit of a kerfuffle in terms of dealing with video conferencing capacity. Notwithstanding, you know, we have phones that can look up a bit of information within a 3-second time frame. It's definitely been a work in process, but I know in the Townsville registry, the court has acknowledged the difficulties with the COVID-19 restrictions and how you might have indicated 3 months ago that mediation parties would attend mediation, but because of the COVID-19 restrictions, that hasn't occurred. And the court, well, in Townsville anyways, has been really mindful of that and has said, look, that's fine, you know, I'm gonna adjourn this. Let me know how much time you need. And so I think that really harks back to what can we do to make sure that the administration of justice is done, is conducted, that we can carry things out in a timely manner. So, how can we help? We have stopped face-to-face contact in line with social distancing, but we are continuing to provide services to our clients in the areas, like I said earlier, back to that first slide, domestic and family violence, to child protection matters, to family law, to victims assist applications, providing support in relation to sexual assault matters. And we are still providing community education sessions and community legal education sessions, but over the telephone and video link. Remember, practice social distancing, everyone. Just tying back to what I said earlier on, we're just adapting to the situation, and I'm sure all of you would have had to implement measures to make sure that you're being COVID-19 safe.
Whilst we have ceased face-to-face contact, we are still operating. You can see our business hours and the manner in which to contact us on a 1-800 number, or alternatively our generic help email, which is regularly checked and emails forwarded to the appropriate officers. I'd like to thank you all for attending today. Thank you, Simone, for presenting. I can hear a bit of a squeaky throat there, so you've done very well. This has been our second PowerPoint presentation that we've run today, and we have really addressed the family law issues primarily from a court perspective. So we haven't looked at, well, what happens pre-court? And obviously those types of matters, I would strongly recommend legal advice in relation to the steps to take and how to actually triage and manage and navigate your way through the family law system, which can be quite complex and complicated for clients, especially those who are already in circumstances of high need, especially if there are allegations of family violence in the background, which we've also highlighted and spoken to today. There have been some messages going around on the chat box around questions, and we are at a time now to take questions. So if anyone has any questions, please feel free to send them through and we can actually have a Q&A time. Just watching the questions, everyone. I don't think I'm getting any questions. That's okay. Look, obviously, if you'd like any further information in relation to this webinar that we've presented today, please get in touch with us. We are here for you and our communities and our clients. I think I might wrap it up. Oh, here we go. There is a question. I won't wrap it up. The question is, how do you measure your high needs cases in domestic violence? I think I've got some panelists as well. If anyone on the panel wants to jump in.
Thelma, can you hear me?
Yes, I can hear you.
Hi, I'm Aaron Lukey, Senior Deputy Principal Legal Officer with QIFVLS. And just in relation to that question, I think the way that we identify and kind of gauge the high needs clients is on a case-by-case basis. What we do is identify the particular matters and what particular areas are in need of high demand. So this webinar is in relation to FCC matters and family court matters. However, when we're dealing with domestic violence, if there is an issue in relation to DV matters, and this matter is going to hearing, for example, we deal with those. The court has protocols in relation to high risk clients, aggrieved matters, and we deal with them that way. In relation to dealing with them in-house, we're very sensitive to those clients, and we deal with them on a case by case. So sensitivity may come around culture, background, trauma. We have an in-house social worker that works closely with our management team. So there are many ways in that we deal with high risk or high needs clients. It's just a matter of case by case. I hope that helps.
And just following on from that point, Aaron, thank you for that. In relation to the high needs cases in domestic and family violence, what QIFVLS has actually successfully implemented in our Rockhampton and Mount Isa offices is the integration of a case management practice model. Our case management officers and our case management practice manager are trained through Case Management Society Australia, and there is different case planning that is set up with high needs cases, particularly in relation to domestic and family violence and child protection. Our other officers also triage and support, as Aaron has highlighted, on a case-by-case basis, our high need cases in relation to domestic violence. And it's really important that we maintain our referral pathways with other agencies who can give additional support services that we don't currently offer at this time.
I know for Townsville, in our office, we're definitely very envious of Mount Isa and Rockhampton with the case management office modeling. But I have to say, from my perspective, I've got fantastic colleagues. I don't actually identify, but my legal support officer does identify, and that's part of our practice model of we're going to deliver service in a culturally safe manner. You know, we're going to conduct these interviews being very mindful of not just, you know, the fact that our clients have been exposed to domestic violence, but to be also sensitive to their needs in terms of culture and what they've experienced. And like Aaron says, it really does depend on a case-by-case basis. You know, you go in there with the need to be sensitive, but really have to adapt to each situation as it comes.
Thank you, Simone. I have another question here in relation to the statistics about Indigenous women being most likely to be victims of domestic and family violence. I think the figure quoted was 32 times more likely. Yes, those figures are current. Those are the figures that we quote and use not only as QIFVLS, as a singular entity here in Queensland as a family violence prevention legal service, but as a member of our national forum, the National Family Violence Prevention Legal Service Forum. Those figures probably are underreported, I would say, but these are the figures that are widely available, and they are, in my respectful opinion, quite damning. So I hope that answers that question. I don't believe we've got, just double checking. I don't believe we've got any more questions. I might wrap it up at this time. Thank you so much, everyone, again. and making yourself available to tune in to this webinar, our second one. I'm very proud of that. This is a historic moment for QIFVL, so thank you in sharing with us. As I've indicated before, our preferred service delivery model is face-to-face, and that's really based on us being able to get out into regional remote areas. But obviously with COVID-19, this has been a bit of a silver lining for us in relation to updating and upgrading our service delivery electronically, and it will complement our ongoing face-to-face service delivery into our communities. Stay tuned to this space. We will be delivering more webinars and videos, I'm really proud to say, and we will be sending out notices to our stakeholders. So keep an eye on that. We'd love to see you again next time, and I'd like to thank you once again. Thank you, Simone. Thank you, everyone. Have a lovely day.